We're going to discuss elements now. So this is a tool that I have developed in order to assist you as a representative, chairperson, arbitrator, anybody who's involved in labor relations matters. And what I'm talking about here, I have applied in everything. If you have a look at the stuff that I've written, you'll see that it always deals with the elements of forms of misconduct and that. So let's move on to explain what an element is. It's a separate objective fact which the employer will have to prove in a hearing, arbitration, or court in order to prove its case on a balance of probability. So again, it's a separate objective fact which has to be proved. Now, say there by the employer. Sometimes employees have to prove as well, but it's a fact that has to be proved by one or other of the parties, and has to be proved on a balance of probability. So there's a standard of that elements have to reach. So this approach has been used because, and I've developed it because it assists the employer, who then knows what he has to prove, well, they have to prove in a hearing or arbitration, as well as the employee, who knows works out what his possible defenses are, and the chairperson or arbitrator, who can assess evidence correctly. Why? Because you use the elements. It follows from this rule of interpretation, the logic that I've tried to set out there. And I think you will find it, once we've been through the exercises here, you'll find it perhaps, I hope, will make even more sense to you. So it's a practical tool for all the parties involved in disputes. So elements can help all practitioners, no matter what role they're performing, to work out the logic of their case. What must be proved first, second, etc. I've given you a touch of that. I'm going to reinforce that now. What they need to prove, what evidence must be led. Now, I've said before, there's a whole section on the law of evidence, and also follows this idea of logic and of elements. So what I'm showing here is very key to the entire approach that at least I follow. And I'm suggesting it's the helpful approach, that you don't have to be a lawyer. You don't have to be somebody who's been to law school. You haven't done whatever. As a sort of lay person, if I can use that term, will be able to apply this. So you work out what defenses are, and then whose version, the employees of the employees, is more probable. Now, I've covered that. Okay, the idea of what can be more probable. One version must be more probable than the other. So what I'm going to teach you is how to work out the elements. And we do that from taking the ordinary meaning of the word or phrase, sometimes they're phrases, considering the logic, and then seeing how that provides the key evidence which needs to be presented. So this is all in the context of of a dispute which is happening or about to happen down the future. You're preparing for it, that kind. So that is how we'll do now. That's the words for in practice. It makes more sense, I think. Exercise 12. To work out what the elements of a particular legal term, phrase, or allegation, to understand what evidence needs to be led and what defenses are available. Right, so there we go. So, question. What are the elements of an unfair dismissal? Okay. What are the elements? In other words, what has to be proved when you say unfair dismissal? What has to be proved? I hope you get this out. First of all, and there's a logic implicit, first of all, was the employee dismissed? Secondly, was the employee's dismissal unfair? So the two elements are, was the employee dismissed or dismissal first, unfairness second? A little confusing because you say, but it's unfair dismissal. Yes, but in law and in logic and using the notion of elements to work out what must be proved, you'll see that you have to prove, was the employee dismissed and then was it unfair? Because logically, you can't say a dismissal is unfair if you haven't proved that there was a dismissal. Does that make sense? Dismissal. Somebody was fired from their job. So those are the elements. There's two elements to an unfair dismissal. Which element must be proved? I've already answered that. Dismissal was unfair if it's proved that he was dismissed. I hope you see this. And then we've covered unfair discrimination, and I've said to you a few times, actually, I showed you in that Bayete case. That's what the law says. That's what the judge says in that case. And by the way, that's an old case. But there are a number of cases that are on that question of wage discrimination, etc., which show the same thing. It's not sufficient just to say, no, it's unfair. You have to show and prove that it was unfair, and then discrimination. Great. So, simple exercise, I hope to start to see the logic in what we're dealing with. I would say to you, by the way, just as a thought now as I'm talking, is that if you don't get this logic, then law's not for you. All right? Then really law's not for you. Push on. I'm not saying give up now, but say to yourself, hey, this is like so confusing, and there's nothing wrong if you find this very difficult to grasp. But if you don't grasp this at this level, then everything else becomes very complicated. Anyway, just a thought. Right, so exercise 13. Now we're getting into some real life situations. What are the elements of insubordination? Okay, so I'm putting that in. You'll see in the exercise, like you're going to help somebody around this question of they've been charged with insubordination, so now we need to work out, well, what are the elements? And why? Remember, because I said it helps you. It helps you work out what evidence is needed and that kind of. So let's work through this. Did the employee fail or refuse to obey an instruction? Was that instruction given to the employee? Was the instruction lawful and reasonable? Okay. Now, where do I get that from? You're going like, whoa, Sean, hang on, back up. Where do I get that from? I get that from what I've just told you. You take the meaning of the word. If you're not sure what insubordination is, you can look it up. But insubordination is the failure or refusal to obey a lawful and reasonable instruction. That's what insubordination is. But now you'll see that I've added, if you like, some other elements, because you say there was an instruction. Yeah, well, okay. But you've also got to prove the instruction was given to the employee. Why? Because the logic says if you're not given an instruction, how can you be told to have refused? Logically, implicitly, it means you have to prove that the instruction was given to the employee. Where do I get that from? Take the meaning, unpack it. The first one is, did the employee, you have to prove if you're charging somebody, then you can't just prove somebody. If you're charging Mr. Smith, it's not sufficient to prove, somebody out there didn't obey the instruction. You have to prove Mr. Smith didn't obey the instruction. So it's, did the employee fail or refuse? Because that's what insubordination. You failed, you just didn't do it, or you refused. You said, stuff you, I'm not going to do it. The instruction given to the employee, and the instruction was lawful and reasonable. All of that is taken from the meaning of insubordination. So now we take it further, because you're asked to, how would you defend this guy who's been charged with insubordination? I said to you, the key thing about elements is that not only helps the employer what they have to prove, which we've just covered, but also helps the employee to show, hang on, these are my defenses. And the only defenses, by the way. So what defenses? To some extent, you kind of revert, you change what the employer has to prove. It's kind of like the opposite. So the first one is the employee must prove that it was a particular the charged employee, refused to committed insubordination. So the defense was, it wasn't me. Secondly, I didn't fail or refuse to obey. I did obey. Good defense. Thirdly, there was no instruction. What are you talking about? You told me, what? No, there was no instruction. The instruction wasn't given to me. And fifthly, the instruction wasn't lawful and or reasonable. Now, there's a whole whack of law. I've got an article on this, etc., written, and I'm about to do the training as well. But you'll see, those are the defenses that an employee can bring. And what I'm saying to you is that there are no other defenses. Those are the defenses. So what I'm also showing to you is that if you are interviewing somebody, as in this example, you would then work out very quickly from what I've taught you. You're taking the statement, you're questioning them, and you work out very quickly what his defense actually is. Now, I would say to you that it's illogical to say all of those are his defense. There would be one, maybe two, that are his actual defenses. And why I'm saying that you bring it down to the one, because then you can nail it. Then you can hone in on that aspect. They charged this guy with insubordination, but he says instruction wasn't given to me. So you'll find that all the evidence in the disciplinary hearing or arbitration is only about whether the instruction was given, because everything else is not in dispute. So whether the instruction was given to that particular employee. Okay, that's how key this is, how very important, how very helpful. Okay, so, there's an example in the slide there, which I should have made. So those are the defenses. It's not a defense to say, well, somebody else was late for work. That's not a defense. The defenses are those 5 aspects that I've set out. Not that statement, another employee was late for work, is not relevant, but it's not relevant as a defense. It's relevant to something else that we'll look at later, what we call consistency. If you remember what we've covered in item 7, one of the aspects of that is that the employer has to apply rules consistently, and that would be an indication of consistency, but not a defense. Do you get that? Great. Exercise 14, work out the defense of a particular concept. Same thing. Okay, what are the elements of a strike? One of the reasons I read that to you is because of this. Okay, so now you're going to take that. Where do you find it? Section 213. Have a look at the Labour Relations Act, and then try and work out what are the elements of a strike. What are the separate parts of the word strike that has to be proved? That you're going to need evidence. If you're going to prove that there was a strike, what do you have to prove? It's not sufficient just to say there was a strike, because there's a definition. So what are you actually going to have to prove? If you need to stop the video here, then do that. Right, so you've done that. You're looking at the wording that we've covered, and you'll see that these are the elements. Employees acting together, refused to work, to remedy a grievance. Right, that's the elements of a strike. So let's unpack that a little bit. You will see it's employees, plural, acting together. Where do I get acting together? Yes, they've used the word they're concerted. But if you had to look in the dictionary, you'll see that that word means that they acted together. In other words, the employees acting together, working together, they refuse to work. And there's also obstruction and all that, but it's all basically, there's some some refusal or obstruction to work. And why did they do that? To remedy a grievance. Now, it talks about a grievance being mutual interest and all that kind of stuff. But okay, but it's a remedy a grievance. Those are the 4 elements that you would have to prove if you're an employer. If somebody said, are they on strike? That's what you would have to prove. Right. So now, one of the reasons is because you have to work out it needs to be led. Okay. What evidence you have to lead to show employees were on strike? What I've just said. That the persons on strike were employees of the company. They were employees. Now that's, wow, whack. Quite difficult. The notion of that somebody is an employee is quite a difficult thing to prove in some situation. But here, you'd have to show that those 10, 20, 300, whatever employees are employees of the company. That they're acting together. That they have withdrawn their labor, refused, okay, and that they did that in order to remedy a grievance. So, do you start to see how this becomes helpful in terms of picturing yourself now in an arbitration court situation? What do you have to prove? I'm saying to you as well that you don't have to be an attorney, you don't have to be legally trained. But you do need to have this kind of understanding. Because if you don't, then what you do is you come to a hearing, you come to an arbitration, it's just like a bull shotgun. And everyone's going like, what on earth? Okay? This leads you directly to the evidence to prepare for a court case or anything else. You show that the persons were employees, that they were acting together, that you can have evidence that they've withdrawn their labor, and that there was a grievance that they wanted to resolve. Okay. So, what defenses could you raise to show that they were not on strike? Well, the first one is that they weren't employees. Strike, employees. Not employees, no strike. Why? Because that's the definition. That's the meaning of the word. They didn't act together. They didn't withdraw their labor. So there was no grievance. So those are the defenses that you could raise to show that in fact that there was in fact no strike. Okay, so I don't know how to explain how important that you get a grasp of this. Now, like a lot of what I'm saying is, you once you practice this, once you start to put it into practice, it starts to make more and more sense. But you need to get the basics idea that there are elements, that you can work out what the elements are. Sometimes you get it wrong, doesn't matter, but you follow this approach and you'll find that you'll be able to deal with the practical things like what evidence do I need, etc., very efficiently.